Good morning, everyone. Alan, um, you're muted, I think, because I can't hear you.
Yes, I am.
There we go. Now, when I logged in, it said recording in progress. So,
Yeah,
so I'll,
they'll pick up our banter
yes, I will, yeah, keep my comments, not profane.
as
Uh,
clean as possible.
yeah.
How are you?
Good, good. Still waiting for the weather to break up here, though. My God, it's cold. It's,
We were out in the Hamptons, and my daughter just started a general manager job at a hotel out there that was
that's right.
undergoing a lot of renovations, and we got everything. We got snow, sleet, rain, 50-mile-an-hour winds. It was like probably 30 degrees when we got out there, and then on Sunday during the rainstorm, 50 degrees.
Wow.
Monday morning, 15 degrees.
Yeah, we never got the 50 up here. And I made the mistake. I actually went out and shoveled like the 2 or so inches of snow off my driveway, and then the rain came and froze. And so my driveway is a skating rink.
A skating rink, yeah.
Yeah. But luckily, I don't walk in my driveway much this time of year, so I don't care.
I was very careful. I had my shoulder replaced. I think I had told you about that.
Yeah.
And I was being very careful. I wasn't even bringing down the garbage because even when we get our driveway plowed, they don't do a great job. And it ices over the next day. So I just did not want to fall on the surgically repaired shoulder.
Nope.
Fortunately,
That's a good idea. Yeah. 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 I had a lipoma removed, which is a little fatty blob.
I know
Oh,
what that is. I have them. They're inherited from my dad, who had like 100 removed.
well, that's nice. Yeah. But yeah, I had one, but because it was like right at the base of like my neck, they took it out, and and then like 2 weeks after, my friend wanted to go cross country skiing, and I'm thinking I fall a lot when I cross country ski, so I'm thinking probably not. It stuck us, a
You
stick.
too? You too?
Yeah.
I love flats and I love climbing, but I cannot control downhill. It's not like regular skis.
Yeah. I just, usually I just end up sitting down, and when we ski and just the forest preserves in the Adirondack, so it's not prepared or safe. I mean, there's sticks under the snow, and
Yes,
yeah.
yes.
So
We have a couple of great areas by me that you can do cross country skiing and snowshoeing. But there hasn't been enough snow in the last few years to do that. It goes away after a few days for us. We've been getting like 1 to 2 inches, 3 to 4, and it's gone pretty fast. You don't get a base.
yeah, well, nothing's been gone here for the last couple of weeks because it hasn't gotten above freezing since
Yeah.
I can't remember. Anyway,
I went up to Orange yesterday, and there was a sheet of ice over all the snow. It was a glaze,
yeah,
but the roads were okay.
yeah. It's a good time to stay indoors.
You said you have to go up to Syracuse, right?
I have to go to Syracuse tomorrow. Yeah, for a case where my client got divorced in 2007 and is now trying to take possession of the accounts that were awarded to her, given to her under the agreement. And of course, they're all moved and gone somewhere. And you
Yeah,
can't,
we spoke about that because I told you about
yeah,
the one that you guys helped me with, where he took everything out of the account.
yeah, yeah. So we'll see how that goes.
Yeah, I
Yeah.
see you're on, Melissa. Hello.
I am on, and I'm trying to get my note taker off, but I haven't figured out how to do that if I'm not the host of the meeting. But thanks. Good to meet you. Is it Robert? Is it Bob? What do you
Oh,
like to, Bob?
Bob is
Okay.
fine. Yeah.
Yeah. So we've been working on some cases together, Bob. It's nice to like see you. I think I have met you. Megley, because Alan was involved with that.
Megley. Okay.
Yeah,
Yeah.
okay, but you know what? We're recording this, so that's I should not have said that. So I'm
That-
sorry. But Georgia, I hope you didn't hear that. But let me I'm bad. Let me so do you know how to remove the note taker once you're on there?
Where is that? I don't even, I don't
You
put,
don't even see it. If you don't see it, then that's good. I tried to hide it. but I wasn't able to remove it. I have like this like relationship with my note taker. I haven't figured it out. It like accompanies me, but I don't know how to it takes great notes. Do you use this? It's the note taker through the Zoom app that you're
I
able to, yeah,
I see under the little more circles at the bottom right of the screen, the little circle with the three dots in it.
yeah,
There's a notes feature in there,
yeah.
but I don't know if that's
Yeah, it's like an app that you can include. It's the AI companion,
yeah,
I
okay.
believe. Yeah,
Mhm. Nope, you know, we rarely, you know, our work is not so complex that we need, you know, lengthy notes.
right,
So
right,
on
right.
this stuff anyway, yeah, yeah.
Yeah, all right.
We require a
So
Yeah.
suit and tie. Do you have one with you?
what is that, Georgia?
If we require a suit and tie, do you have one with you?
Oh,
Oh.
oh, look, you're kind of matching with your
Yeah,
color.
Georgia, did you and
Yeah,
Bob
what is
also
that?
talk
Did you
about
coordinate
This, we talked yesterday, yeah.
Oh, yeah, we sure did.
plaid flannel? Look at the both.
Yeah.
Almost plaid.
Alan,
So,
thank you. Love. That was really
yeah,
very, very nice.
yeah,
And I think he's going to take over most of the discussion because the stuff that I was studying, he knows.
okay. Well, this is going to be really informal. I don't know how many people, we never know how many people come because this is a thing, Bob, that we have the third Wednesday of the month and as a continuing series. So people, if they sign up for one, they can sign up for the whole year kind of thing. But I do think we've had about like, you know, at least 15 new ones that I saw. So I don't know. I have no idea. It might just be 15, might be 10. It's going to be more than us, I'll tell you that.
Yeah, yeah. Listen, people are busy. It's you know, it's hard to get people together
It
anywhere,
is,
even Zoom.
Well, we do
it
these
is fun.
things either first thing in the morning or we do them at lunchtime.
Yeah,
Uh,
yeah,
And it's probably
yeah,
the best way to do that because we get, into our day probably pretty early. This is,
right.
I work into the evening
Yeah. Oh, wow. Okay.
because I'm just not a morning person. Somebody may have noticed that when I did it from bed.
Yeah, we did pick up on that.
But now I've
Yeah.
learned to
I
try
taught
to do
during
something.
the COVID era, you know, and everything went online and you know, every now and then you'd get a glimpse of someone's, you know, dorm room or something, you know, but even worse than people like, you know, being in bed or something was that everybody everybody muted their cameras, muted their microphones, you know, so for a year, you know, I sat in my living room and I talked to myself for 100 minutes straight, you know, it was horrible.
It must have been fascinating.
Yeah. Yeah, for my wife who was in the other part of the house.
Yeah.
when you
So,
started answering yourself, everybody thought you were in a bit of trouble.
That's right.
right,
Yeah.
right, right. So Bob, I don't know if you're gonna be, are you gonna be wanting to share a screen or are you just gonna be speaking? This is gonna be like very informal where people, I don't know how you want to do it. If it's just gonna be like a conversation where, you know, if people have questions, I mean, do you have, I don't know what are you doing like something more formal or a discussion? I don't know how you're
I
planning this.
I am not. You know, you said you know, I got kind of debriefed with Georgia yesterday, and I think there's not a lot of, you know, visual aids for you
Okay,
know, talking about dividing a 401k, but I could, you know, just kind of run through what the process looks like from our end.
sure.
And
Okay,
then, you know, some of the things you know, the problems we run up against and where it'd be much easier if they're addressed, you know, in the separation agreement before it gets to us. But and then yeah, questions are always easier than to just, you know, talk
If
nonstop.
you absolutely need to, you could go to the other retirement assets.
Yeah. Yeah, we talked a little bit about IRAs. I think with just, you know, regular pensions,
Yes.
there's a lot more pitfalls. But honestly, I feel like if we want to do something on regular pensions, you know, for that, you know, state and federal, you know, stuff, I would definitely haul in Carolyn, you know, for that because she, you know, as they say, she knows more about New York State pensions than you know, she's forgotten more than I know.
So we'll reserve Carolyn for that.
Yeah, yeah, and Carolyn does,
municipal pensions.
in the military ones, right? I don't know how many military bases you guys, we've got the Scotia, Air Force Base here, and you know, eh, yeah, when Carolyn was out sick, I was inclined to not even do the military pensions because they are such a pain in the neck. DFAS, I think part of their job is to, make it as difficult as possible to divide, military pension.
So, correct me if didn't we have Carolyn do one within
Yeah.
the last
Oh,
couple
yeah,
of
we
years?
have, we definitely have had, yeah.
But a long
Yeah,
time ago.
Yeah, so we do this, Bob, this is like our pod meetings, which are, we don't offer credit. It's more like an informal discussion. It came out of more like of, more regionally based within our organization, just a way of kind of bringing in other professionals and a way of networking in our local little practice groups. And then since Zoom, or since COVID, and then Zoom, this has kind of morphed into a Zoom platform primarily because we have it in Northern Westchester, we have it in the city and the island. And so, but so for what so we also have our training and education that has more than an hour. We usually have like an hour and a half at least or more that we also offer credit. So if there's an opportunity to get more deep into, because some of this does require a lot more, just a little bit more time to unpack a lot of these topics in a really full way, we definitely would welcome that opportunity. And I think that Carolyn has spoken to us on one of those training and education because we
Yeah.
have these like Friday webinars. I know she's spoken a few times. I've seen her so many times over the years of being a member of like the Mediation Association and all these other associations. She's amazing. And I hope that she's doing okay. Because I know that she was affected really profoundly with COVID. That was
Long COVID. Yeah, long COVID. It's one of those things you read about it, but until you know somebody that's got it,
I know, right?
you
It's
don't
I
appreciate
know a few people. It's not easy.
it.
All right, for sure.
Yeah,
Well,
yeah.
I picked this group because it's the friendliest, most casual. And when I don't know, I don't feel embarrassed to say, gee, I don't know. I'll tell you next time.
Mhm, mhm.
Right.
Um,
Yeah,
so,
it's a good group of people.
yes.
All right, so we'll get started soon. We have Ellen on. Ellen is now, I'm the immediate past president, but Ellen is the president of NYCP. Ellen, have you met Bob before?
No.
Nope.
Okay, so this is Ellen Jacob Bacon, who is
Hi,
the
nice to meet you.
You
Yeah.
too. And Donna, again,
Oh,
I know the
yes,
names.
Donna.
I know the names, but
Now you're seeing the people, right?
yeah.
All right.
Everybody send him a snapshot so he can figure it out.
You can take a picture, right?
Yeah.
All right.
I must
Oh.
say, the guy, when we put together the firm last year, or Carol and I, we went to get pictures for the website and stuff, and there's a guy here in Albany who does our photos, and we were both amazed at what the guy could do with Photoshop to make us look presentable.
Right? Oh my
You had
God.
hair?
Yeah, I know he did. He's not a magician. He's not a magician.
Yeah. Yeah.
Mhm.
Yeah, our practice med our executive director, the people who manages our organization, they're based in the Albany area as well. Bob.
Well, yeah, there are worse places to be, but not this time of year, but other times.
Yeah. Oh my goodness.
Like me,
Right.
Bob is a cyclist. He's a real cyclist. He still rides outdoors in this weather, which is something I have.
Oh my God, that's
Yeah.
treacherous.
Well,
Wow.
I have a fat bike with 4.8-inch tires, so you can get by.
Yeah, but that ice though, isn't ice like how do you deal with ice?
So you ride in the
Don't go
woods.
on it.
Yeah.
Avoid it.
You're right in the woods. And hope that the trees aren't falling on you when it's windy.
Oh my God.
That-
All right.
Yeah, I gotta get Al on a fat bike and have him come up to the Adirondacks.
I was out in the Hamptons, as I mentioned to you, Bob, and I want to buy my daughter a bike. So she was looking at some of those fat bikes for out there.
How many
Yeah, they're good for
wheels?
sand. Good for sand. And as they say, they dumb down the trails because you don't have to worry about what's in front of you. You just keep pedaling.
Right.
All right, so I think we'll get started, and I thought, Alan, you would be great to kind of introduce Bob to our pod attendees, and Georgia. This is part 2 of our retirement series. And we've included Bob for his expertise on the area that we're going to be delving into today. So, Alan, did you want to kind of do any kind of brief intro?
Sure. Sure. I met Bob a few years ago through Carolyn D'Agostino, and then they formed the law firm of D'Agostino Jones. Bob has a long history in the matrimonial field, starting with being a business appraiser before he even got his law degree. And in the last few years, he and Carolyn joined forces, and Bob is an expert now in the areas of domestic relations orders, pension, retirement accounts. His firm does consultation services for settlement agreement language, which I've availed myself of many occasions. The pension valuations, and they still do business appraisals. And I think Bob will be very helpful in this particular setting. Georgia did a great job in part 1 of this, and there was so much to cover in part 1, we decided to do a part 2. Georgia, introduction. Georgia, your reputation precedes you, so I think with that and no further ado, let's get started on part 2.
Part 2, I'm going to try to focus on 401ks because we can actually try to accomplish that. But as practitioners in this field, we are constantly faced with the absence of people of Bob's caliber to explain and help us draft and point out the issues. What we really have to know is that the important document is the agreement. The quadro is just a means to achieve what we say in the agreement. We can't leave the quadro to the end. We have to have the quadro language at the beginning, because otherwise the mistakes have already been made. So the critical place to put the terms is in the separation agreement. Then it is painful to try to correct a mistake. And it's not superseded by a quadro. The quadro is supposed to reflect the separation agreement. So step number 1, we're really interested in how to and what is the impact of the division, and less so, how do we accomplish that through the agreement and then through the quadro. And this stuff is so complex because we have to deal with very different laws. We have ERISA and we have the Internal Revenue Code. Then we have the domestic relations law. And then we have every plan with its own rules. So in order to give us more insight, I'm going to ask Bob to discuss the 401ks and how you approach it and how we should.
Great. Thank you, Georgia. I think the sequence is well set up, going from the IRAs to the 401ks, because both of them, as you know, are defined contribution plans, which means that there's basically a cash dollar value assigned to them that's observable, right, and then fairly readily split. One of the advantages with 401ks, though, is that they are qualified plans, and we can get them divided with the domestic relations order. My experience with the IRAs, because they're not qualified plans and therefore not covered by ERISA, is you can run into more difficulties with the IRAs because of the custodian, right, isn't bound by the court order. Right, you can send them a court order, and they say that's fine, but we have this document that we use internally, has to be filled out, has to be signed by both parties, and you got to do it the way we want, or otherwise I guess you could sue us. So in those cases, right, I've had situations where we get the forms filled out for them, and then somebody doesn't want to sign, right? Whereas with a 401k, right? I don't need the signature of the participant or the alternate payee. I get the court order, right? It goes off to the plan administrator and they do it. So in that sense, the 401k is, I think, a much easier vehicle to divide. The other place that they're typically easier than the IRA is when you've got the assignment of gains or losses. With an IRA, the custodian, I've never come across an IRA custodian, whether it's Merrill or JP Morgan or whoever, or Schwab. None of them are going to calculate gains or losses for you. But with the 401k plans, almost all of them will, right? So if we tell them to give the alternate payee, $100,000 as of July 30th, 2022, plus gains or losses, right? That's adequate. They'll do that calculation for us. What they won't do is that they typically will not, in fact, I've never seen one that will, they will not determine the marital portion. If you tell them to, give the alternate payee, 50% of the funds accumulated between, January 1, 2000 and January 31st, 2022, they're going to say no. So we'd have to go back and get the account statements to determine that premarital separate property component, and then track the gains or losses, right? So or some of the, just the key distinctions with the IRA and the 401k. Let me back up then and just kind of start from, how our process works. If we're dividing retirement assets, typically 401ks, we, electronically send out the retainer agreement. We get a copy of the judgment of divorce and most importantly, the separation agreement, right? Because we are bound by the separation agreement by the time it gets to us. If it's already been, signed and incorporated into the judgment of divorce, we don't have the latitude to unilaterally, alter any of that. Occasionally, if we are jointly retained, and if we see language in the 401k, or in the agreement that we think is just not going to work, we will check with the parties to see if they want to, amend the agreement. And, because we are a law firm, we do have the ability to, to draft an addendum, for them. We typically recommend that they go back to their divorce attorneys to check with it if they so desire. But typically that, addendum, I'd say that the number one reason why we try to amend agreements from time to time is if someone's referenced the Majauskis formula, dealing with a 401k. And we don't do that lightly, but my concern, with the Majauskis language on a 401k is that the participant has the ability to affect, right, the contributions during the post-commencement time period. They could effectively, right, turn them to zero and then just run the clock out, making the denominator bigger and bigger and bigger, right? So that the alternate payee's share of the account would get smaller and smaller. So, in an environment like that, I'll just ask them if it was their, I don't like to put words in their mouth, but I just point out that, this is problematic. And, you might want to go back to your divorce attorneys, but if your intention was to divide this account, as it exists, now, based upon what was contributed during the marriage, we can do that through a tracing approach, and get it divided now. Otherwise, you're going to have to wait, right, until the participant retires before you can get your money, because you can't do the calculation before then. So that's I'd say that's the most fearful, situation.
And there's the inverse, Bob, which is people can leave their jobs as soon as the quadro is done, and it's based upon a percentage of the ultimate salary. You simply say, bye, we're freezing it here. I'm going to another plan, to another state or another company and therefore reduce the amount that's going to be divided.
Yeah, there's so many potential pitfalls there. I mean, I still have an account with an employer 401k from 20 years ago, right? Because I just left the money in there and never moved it. And there's been nothing contributed for 20 years, right? So yeah, it's potentially very
Does your
problematic.
wife know that?
My she keeps a good eye on where all the money is. Yeah. So again, that's starting back to the process. We get the judgment of divorce, separation agreement. We have an intake form because obviously we need names, birth dates, social security numbers, addresses and that sort of stuff. And then, we size up, what kind of account statements we need, whether we're going back to measure separate property and trace it through. That's another place where it helps if the agreements are clear, and that is whether or not you're going to simply give the participant credit for the premarital balance. If they had $50,000 in it in 1999, are you just giving them credit for the $50,000, or is it going to be the $50,000 of separate property plus the investment gains or losses, right? Because passive return on separate property is separate property.
And that's always a difficult area because there are different times of contributions. How do you really figure out if you're going to do a real calculation on the gains and losses on that separate property contribution?
Yes, so that's why we have to get the account statements. Sometimes, if you're fortunate, if Fidelity is the plan administrator, typically the quarterly account statement will tell you the investment return. So that would be, that investment return is independent of the contributions. If they don't actually do that calculation for us, then the account statements will typically give us beginning balance, right? Contributions, withdrawals, and then there'll be a line in there for investment gains or losses. So we'll take the investment gains or losses, divide it by the balance to figure out what the return was over that time period, and that's a manual, right? Manual process, but it's if you have a spreadsheet built that's done it, it's not. The calculations are certainly not as difficult as getting the statements.
How far back does Fidelity go with their statements?
I'd have to check. I'd say I get those statements back, routinely, yeah. Trying to think of a recent Fidelity one. I'd say I'd be comfortable with Fidelity, at least 10 years, and I may have ones further back than that. Tia Cref is the one that now has the hard 7-year cutoff. And that's not very long when it comes to a divorce. So, yeah. So, yeah, are we going to give them credit for the gains on their separate property or not? Sometimes I think the attorneys cover it when they say that we'll divide the marital portion of the 401k. Right. So, when I read that, my interpretation is that, when you say marital portion, right, since passive gains on separate property are still separate property, so I would default, conclude that I have to trace the separate property from the date of marriage, through to make sure that I'm only dividing the marital portion, which would be the part that was, contributed during the marriage. Yep, I see a question.
Hi, thank you, Robert. My question is, when you do, because I've had a couple of cases here, when you do the appreciation of passive gains and losses, and I think we've all done 7th grade math, and we look at what's the appreciation rate over the 20-year period. So if it's 10%, I just add 10% to the separate property. And I'd like to do a program on this. It's really not mathematically correct, because what you're not doing if you just add the 10% is the compounded interest over time. So if I invested $10,000 in 2000 and my account appreciated 10%, that $20,000 is worth a lot more than $22,000. It hasn't just gone up 10% because of the compounded interest of the time element. And what I'm looking for is a presentation on how we really appreciate separate property in retirement funds.
So that is a math, problem. When you say appreciated 10%, I guess you just want to be more specific. Has it appreciated 10% or is it appreciated 10% a year?
Whatever. I mean,
So-
whatever
so if
way
it-
you do,
Right.
yeah. So
We-
if you do 10% a year, you take it, say the separate property date of marriage is 2000. So you do 10%, you do 10% for the next 24, 25 years,
Right.
and you
we-
compound it.
Correct, right. And and again, it is true with some of the statements will give you quarterly and prior 12 months returns, right? And we can certainly we can save ourselves, like 75% of the time by using the annual returns. But we would compound them, each time period. So if it was, if you had a 10% return each year, right, you're right, it would go from 20,000 to 22,000 in that one year, but then 10% the next year would not be an
Right.
additional $2,000, it'd be additional $2,200. And so you're absolutely right. You have to make sure that the math is being done kind of multiplicatively as opposed to additively, right? Simple interest. We're not doing simple interest with those returns.
Thank you.
Yep. But yeah, it's one of those details, over 20 years that makes a big difference. And it's not uncommon to have 20-year marriages. Sure, I see another question. Yeah.
Hi, good morning. I would just add that many times these statements don't actually have a percentage rate of return applied in any given year. So many times you'll take the difference in the value and the investment value and do a pro rata, a portion to tracing the separate property from month to month or quarter to quarter or year to year relative to any contributions and or appreciation on the marital portion. So it's just a math calculation year to year, looking either at a dollar value and or a percentage, but making sure that you're doing it proportionate to whatever that separate property piece had been from the very beginning. Thank you.
Mhm. Yeah. I guess to kind of circle back, right, to the process, we do get the statements. We do try to track, the separate property, provided that the agreement, has allowed for it, either explicitly giving them credit for their gains on their premarital portion, or using the language, dividing the marital portion, because I interpret that as meaning they get, the credit on the appreciation of their separate property. And from there, we just go into the mechanics of the language, right? Of just making sure that the order, gives the names, addresses, dates, valuation dates, are important in the agreement a lot of times. And I had a terrible case. I was neutral on the domestic relations order, and the agreement specified like 3 accounts. Said we're going to divide this account that has a balance of 100,000. This one has a balance of this, and this third account has a balance. But of course, the agreement was written well after the commencement date of the divorce, and the husband's employer was making contributions, and there'd been like 40 grand put in over the 3 years after the divorce. So I drafted the order, right, to be based upon the date of commencement values, and the wife balked. And I told them, I'm jointly retained. I don't decide the disputes. So wife's attorney, filed a motion, and not only got the value of the post commencement contributions, but also got counsel fees. Because the judge said, well, these were the values stated in the accounts. This is what you intended to divide, even though it said, divide the marital portion. So, if you're putting him in, I say for descriptive terms, right? Because I think it's not an unreasonable approach when you're specifying the accounts to be divided. If you give an account value as of some date, it just helps us identify to make sure we have the right account. But you just want to be careful to say that the accounts are going to be divided as of, date of commencement or date of agreement, right? Whatever date you want them as the reference date, it'd be great to have that in there. Also great to have an account number, if you can. Not all 401ks necessarily have account numbers, but identify the 401k plan as opposed to the husband has a 401k, husband has a 401k with his employer. Yeah, a husband has a 401k plan with GE or IBM, right? IBM changes its retirement plan every 6 months, just to make my job difficult. So yeah, get an account statement. I guess is my best advice. Get an account statement and just see what it says, right, on it. And closely related to 401ks are the 403bs, right? I have something on my desk right now I'm working on. It says husband has a Voya 403b, of virtually no value to me because he doesn't work for Voya, right? He works for probably a school district, and Voya is probably the custodian of the account, but that's not the name of the plan. So I have to go find the name of the plan. Now, not a problem if you've got the
But
participant.
ERISA requires the name of the plan. That's
Yeah,
part of the law.
yeah.
So
I
what
have to
happens if
find
you
it.
don't have it?
Oh, I
If
have
you
to
mess
find
it
it.
up, is it
Yeah.
a valid quadro under ERISA?
I wouldn't even know where to send it. That's the problem, right? So I'd have this lovely quadro, and I could try sending it to Voya, but it's not going to get me very far, right? Typically, that's just for nomenclature, right? You've got plan sponsors, typically the employee, IBM, or the employer, IBM. Right. And then you'll have the plan administrator, right, which is sometimes still the employer. And then you have the custodian, right, that actually holds, the assets. And sometimes you'll have a third party administrator, right? And those are the ones that are going to review your domestic relations orders. So once again, part of the challenge sometimes is just figuring out, who is who. Online, there's this website called, if you type in Form 5500 lookup, FORM, and then 5500, just Google that, Form 5500 lookup. You can see the names of the various, 401k plans and pension plans, if you can at least get part of the name right when you're searching for them, because they have to file the Form 5500 with the IRS. And it will also tell you the identity of the plan administrator, which is typically who we are looking for.
If that information or any of the required information is missing, what does one do? In the court system or wherever?
So we obviously have a client. Half the time we're going to be the alternate payee, so it's a little more challenging if we're not getting cooperation. But Fortunately, almost everybody these days has that section of their separation agreement with the further assurances clause, right? That says that they'll cooperate in, signing documents or providing documentation, to implement the terms of the agreement. So when push comes to shove, you can always, file a contempt motion, which of course, is, creates its own set of, difficulties and fees, but usually that, gets the cooperation. And
Last time I talked a lot about malpractice and the fact that we all confront that in this area particularly. And Bob gave me this wonderful insight into how his firm works and why we should all hire them instead of hiring so-called experts. Okay, you can sell now.
yeah. So this was when I started working with Carolyn, so George had asked about our fee structure, right? We get $1,650 to prepare the first order, and $1,100 for each additional order. And we know that we cost more than the quadro preparers. But the distinction is, that, well, one, we take over the matter, right? The domestic relations order is now ours. We have a retainer agreement with the client. It's our professional liability, not yours. We can send out subpoenas, right, to get documents if we need them, and we can, file contempt motions if you don't want to. So yeah, there are problems. If there's mistakes in the domestic relations orders, we're the ones who are going to be sued. And many of the people we work for have language right in their divorce agreements that say they don't handle the domestic relations orders. So which works out fine for us.
To tell us the contrast with firms that are not attorneys or do not have that in their retainer.
Well, they're not sending out subpoenas. They are not, filing contempt motions. I'm not sure. I guess they probably can't even upload to NICEF. Would be my expectation. So yeah, we take over the process as much as we want. Sometimes the attorneys want to stay copied on it. As a courtesy, we typically will send, copies of the proposed orders to the attorneys. Honestly, if I was in their shoes, I don't know if I would want to review it, just because you might pick up liability. But nonetheless, I could see as a professional where you might want to see things, through to the end, for your clients. But yeah, so we take over the whole process. We draft the orders, we get pre-approvals, we submit them to the court. We get certified copies, file them with the clerk, send them back to the plan administrator. Technically, with our retainer agreement that says once we get the final acceptance letter from the plan administrator, our engagement is concluded. That said, we get phone calls, as with retirements, we'll get a phone call 2-3 years down the road. I've yet to tell somebody, that I can't help them because they, it's been too long and we're done. So we do some post, conclusion, post engagement handholding from time to time, with some trepidation.
What about drafting the clauses in the agreement?
Yeah, so when we, if we can get people to agree, right, we'll draft the modification language, to make things clearer. I'll tell you what, I'm glad you asked that, because one other thing that we often do as well, if we get the parties to agree, is we net defined contribution transfers. Right. So if there are 3 401ks, right? Let's just say husband has 3 401ks, we could draft 3 orders. Or we could figure out how much money is owed to the alternate payee and draft 1 order. right? If there's, 3 accounts for the husband, 3 accounts for the wife, right? A lot of times the agreements are drafted to split them 50-50, but nobody needs to pay for 6 orders, right? So we will look to see if we can net payments. Now, you guys seem pretty astute at math, and I'm sure some of you are already thinking about this, right? If you're netting payments and the parties are entitled to investment gains or losses, right? Unless all the accounts miraculously grow at the same rate, right? You're going to have some, some slippage, right? In the transfer, right? We're aware of it. We talk to the clients about it. Most equity accounts, right, will not have substantially large differences in their returns. But if you've got a bond fund or a money market fund, right, versus, a growth fund, those could become issues. So your clients may not want to net them, right? So it's a question, and the duration of time. If it's, if you're talking about the difference in the returns for a year or two, probably not a substantial amount of money. If you're talking about it for 10 years, going to be more important. And the question is whether you want to pay the extra $1,100, for each order, right? So,
You sometimes represent as one of the parties.
yes, that also makes a difference, right? If I'm just representing one party, and there's ambiguity in the order, I'll draft it in favor of the person who's not going to sue me for malpractice, right? Which is my client, right? If I'm neutral, it's, I have to go back to them if there's ambiguity and, either get them to, agree upon the resolution or kick it out, back to the divorce attorneys, because as a neutral, I can't pick, a side in the argument, unless there's clearly a legal basis for it, then I'm fine. But in which case it's really not an ambiguity. But absent that, if I have something that I can't, that is just omitted, even something simple, right? Like, how you're going to split the review fees, right? If it's not there, I would probably draft the order 50-50 or proportionately. Either one of those strikes me as being potentially a resolution, and go to the parties and see if it was okay. Fortunately, a dispute over, review fees, you're usually talking about, a few $100s. No one's gonna litigate over that, but, those are the kind of things.
You're talking about modifying. What about drafting the initial document, the initial separation agreement that tells you how to divide the retirement assets?
Yeah, we've done
People
that.
ever call you that early?
Yes, they do. There's some attorneys that are, more apprehensive about that than others. For us, the challenge with that is, we just want to make sure, right? I think our biggest concern, when we're called in at that point, right? Discoveries, largely advanced. We don't know if all the accounts have been identified, but we can certainly draft language to specify, how to divide the accounts that we know exist. And then we could certainly, I think if this is what we do, right? If people paid us money, we would help search, for assets, right, as part of the discovery process, but we don't typically get called in that early.
Bob, there's a degree of complexity when we're dealing with pensions, which I know you haven't gotten to.
Yep.
Especially New York City pensions, where you have like VS drops and you have other aspects of the pension that may not be covered, and we're not expert in that area. Isn't it a good idea for us to consult with you when we're drafting, splitting those types of either police pensions, fire pensions, city teacher pensions. Can you
Yeah.
just?
Those, admittedly, again, and this is an area where I would often talk to Carolyn, but yeah, I've done enough in the past, couple of years of the police pension stuff to see, you've got the variable supplement fund, you've got the delayed retirement, OP something, I don't know what it stands for. And yeah, all those things, have to be mentioned, right, in your separation agreement, to make sure they're going to be handled properly. And frankly, it may just be an issue of, how much time you have. If you call me and ask me those questions and I don't know the answer, I can't help myself but to look for them, and figure it out, because I'm sure I'm going to see it again. So I am happy to help with those sort of things. And a lot of times I even do that prior to being retained, because I don't want to get involved in a case, where if I don't know what I'm doing, so I'll look first to see if I can sort it out before, committing to somebody with those sort of things.
What happens when you've already done the quadro and it's been approved, and then you find out that the plan won't do it, or the administrator won't do it, or how do you deal with that?
So my experience has been, and we have, we have had orders pre-approved and then subsequently rejected. But they almost always tell you why they rejected the order. I don't know, other than the military, I don't know anybody that just sends you an order and says, no, we're not going to do this, right? So they'll tell you why. And
then what?
honestly, we fix it, to get it through. Sometimes, and again, this is going to be more with pensions than with 401ks typically. But I think you and I talked about this in our prior discussion. We've tried to. I had one where we wanted to just award a certain fund, certain mutual fund from a 401k plan, and the employer said no. Can't have it, so this guy, had an account, it has 3 different mutual funds, and it said, the wife gets, this fund. Drafted the order, and the plan administrator said, no, can't do that. It's got to be pro rata across the funds. So at that point, you got a choice, right? You can alter the agreement to try and compensate the alternate payee for the amount that was promised to them. Or I guess you could try suing the plan. Which
Did the court administrator or the court say that? Did the plan administrator or the court?
The plan administrator said we won't do it.
Not the court.
Right. No, the court signed the order. Right.
Yeah, I don't think courts want to be involved with this. So
No.
they basically rubber stamp anything we give them.
Right. And
Has 2 signatures, that's it.
yeah.
What?
For the court, if it has 2 signatures, that's it.
Right.
Exactly.
Yeah. So, in instances like that, so what we tried to do is in that particular case is we can see what the fund is, right, and what the fund has done. So we just, tried to get the alternate payee the same amount of money they would have had, right? And that's the nice thing about 401ks, right? Is at the end of the day, you're just trying to get a certain amount of money transferred. And there's a lot of different ways to do it, right? You can specify percentages of the account, you can specify dollar amounts, and get to the same outcome.
What if it's already been transferred, Bob?
If it's already been
implemented and somebody says, wait a minute, this was an error, this was a tax error or something.
We've amended, we file amended orders. I would like to say that we don't, but we do. I said, we had one where we transferred the money out, went into the spouse's IRA, and then they reached an agreement, that, what happened? They came to us. This wasn't our error, but the money had been transferred. They came to us and said, you know what, the transfer was too large because it was specified as a percentage of the account, and there were employer and employee contributions post commencement. So, that was a mistake. We want the money back. Well, you can't unring the bell, in that instance. But we could calculate how much extra money was paid, and then we transferred the money, back out of the alternate payees now IRA. So in most instances, when we're dealing with these 401ks, right, it's just money, and we can calculate, what's supposed to be, transferred. And, you're almost like always able to do that. In contrast, right, to a botched, pension order where they're not going to do arrears for you, right? So it is easier.
So when you have a botched pension order, what do you do?
What's it depends how it was botched, right? If it was because someone made an election they weren't supposed to, someone would have to tell me the particular part of the code for that type of motion, but you can modify elections after they've been made if they were made contrary to, the terms of separation agreement, or a court, an existing court order. So some of those can be fixed, if the agreement was just drafted mistakenly, then you got a tougher road to hoe.
I don't understand. Our clients would fight about it. They would never reach an agreement. They say, sorry, that's what we wrote.
Yeah, no, that's true. And sometimes that happens, right? Then it's not an error, right? Then it's not an error. It's just separation
It
agreement.
may not be a mutual mistake, but it sure is a mistake.
Perhaps, but the court, I think, would look at it and see it the other, right? They see it the other way. Said you agreed to it. So, yeah, that's the case. Trying to think any other unique 401k. Oh, the gains or losses, the other place where it pops up, where we end up manually calculating gains or losses. This one sneaks up on us every now and then. So the date of commencement is 2019, right? And they take their time getting around to us. We draft the order in 2024. We send it over to Fidelity and say, give them, give the alternate pay $100,000 plus investment gains or losses since 2019. And they send it back and they said, we didn't take over the plan to 2021. So, we can't calculate the gains or losses any earlier than from 2021, right? So that happens to us from time to time. So you have to go back and get the old statements, right, from wherever the plan was in 2019, grow it yourself to the earliest date where Fidelity took over, and then tell them to calculate your gains and losses going forward. Again, I'm not sure if these are your problems as much as they are mine, but just, they exist, right? And someone looked like they had a question.
Yeah, I think Carmen, thanks, Bob. I think Carmen and then Ellen. Carmen?
Yeah, thanks. So Bob, just going back a sec to the example you gave where too much was transferred, because there had been additional funds that had been contributed to the 401k, and then it was transferred to the other spouse's IRA. So then a certain amount was then transferred, but where was it then transferred to? Just to spouse number one's other IRA account, or like where did you transfer those funds to?
Yeah, there are some 401k plans that will take in external funds, and some won't. So if your 401k plan allows, for contributions, from external sources, then we can move it back. If they won't, then you're setting up an IRA, right? A rollover IRA for that situation.
So in the example that you gave where you said, the bell's been rung, it can't be unrung. So in that case, you just created a separate IRA.
That one did go back to an IRA. Yeah. Yep. For the participant, he had to create one. And sometimes people are picky about that. They really like having their money put back into their, deferred comp, New York State deferred comp account, which there's another one. And sometimes you can't do it. And, my personal take on it is, typically the 401ks, they have fees associated with them, right? There's management fees associated with 401ks that come out of your account. Whereas your IRA, typically maybe you've got a $20 or $40 a year, IRA fee, but you do pick up all of the, discretion, in your investment alternatives. So, personally, I don't see much of a reason of a preference for the 401k versus, having your IRA. I think they get more flexibility with the IRA. I can only think that maybe some people just don't want that flexibility and, want the security of knowing that their investment choices have been pre-screened, if they don't have their own investment advisor. So, but there was one other question before but it did
Yeah.
trigger my thoughts. Yeah, Ellen?
Ellen?
It's kind of a question, but something I wanted to point out. The old adage, you learn from your experience. I'm in the middle of trying to get a quadro, a division of a 401k done with Schwab. And I didn't draft the agreement. I was a consulting attorney, but I learned that the husband's account is what's called a PCRA, which personal choice, and they will not calculate investment experience. So now we're fighting over, well, how are we going to get that done? And who's going to pay for it? And I don't know how you would find that out while you're, doing discovery, that this is what it's called. But
yeah, so that's probably an IRA, isn't it? I've seen the
no,
PCRA.
it's not. It's a 401k.
It's a 401k. Is he self-employed?
No.
I've seen the PCRA. And I've divided them, but I didn't pay attention to whether or not it was actually a 401k. I just can't remember. But interesting. Yeah. So there's another one. So New York State deferred comp, right? Technically a 457 plan, not a 401k, but for all practical purposes, works the same way. They will not calculate gains and losses for you either. They stopped a few years ago and just said, we're not doing it anymore. Tia Cref won't do it.
Then does it, you do it?
Yeah, we do those. Again, it's it's not hard math. You just have to sort through the statements, right? It's great when you get quarterly statements. Every now and then people, get monthly statements, when you're doing, 19 years of monthly statements. Not my favorite job, but once again, if people give me money, there's a lot of things I'll do for them.
You have a list?
Yeah. So.
Well, there are a couple of questions in the chat box going back to the IRAs. Kathleen had a couple, and so did Lily. Kathleen's first one, my understanding is that you do not need a quadro to transfer IRA funds to the other spouse. Can the participant just transfer without a quadro? So we could do that one first.
Sure. Yeah. I mean, the answer to that is most of the time, they just have their own internal transfer forms, letters of instruction. Schwab has its own form. I think Fidelity has its own form. The principal has forms. But some of them want a court order. So in those cases, I usually contact the custodian first. If I don't know, what they're going to require, like, Macaray, right? Some of these, firms that are not as common as a Schwab or Fidelity. And especially if there's a real person who's their investment advisor, I just get permission to talk to them and I call them and ask. So, hey, what is it? Wells Fargo, what is it you guys need? Do you just want a letter of instruction or do you want a court order? And I'd say about 25% of the time they'll want a court order, and the other ones will just take, the letters of instruction or these forms that you fill out.
So being an attorney, what we do is they have no legal right to tell me that I can't transfer my IRA to my spouse without a court order, and no one's challenged it. But because I've discussed with my clients, like, you don't need a quadro. But Fidelity, they're the big guys, and they say you need a quadro. But I'm just curious, it's easier just to comply
That's
than to
exactly right.
challenge,
Yep.
but there is no legal reason why, because it's not a qualified plan. So we do not need a quadro to transfer IRA funds.
I think the concern, again, you could, right? You can sue them, right?
You want to pay me to do it? I'll do it.
Right.
Or-
That's what I tell the clients, or we can just do what they want. I guess
We
my
can move
concern,
the money to another institution.
but
That's interesting, Georgia. Oh my
that's
God.
true. But the other issue, and again, I think George and I mentioned hit up on this briefly as well. I think by giving them what they want, it just ensures that you're not getting the 1099 for the participant, right? Because I would just be wary that if the participant, without any documentation whatsoever, simply said, "I'm transferring this money to my wife," they'd say, "Fine, here's your
No.
distribution." Right.
No, that would be a great lawsuit. If I have a
Yeah.
divorce judgment and I transfer IRA funds and Fidelity sends a 1099, which they're not entitled to do, I'm not afraid of that.
Yeah, well, like I said, you can always fight them. But I agree. I don't think, if the transfers are being done by some brokerage firms without orders, then I don't think there's a legal basis for them requiring an order, right? Otherwise, the other firms would be,
Well, it's very simple. You don't need a quadro to transfer an IRA tax-free.
But Kathleen, when I started, I said, you have all these rules from so many different places, one of which is the institution.
Exactly.
If you've signed up for an account there and you've agreed to their rules and regulations, it probably says something buried in page 48 that you have to have a court order to transfer money pursuant to a divorce.
Georgia, I will challenge you to page 48.
Okay. And I usually just have both clients go in to the institution and have the transfer made that day. And fill it out. I'm on the phone and say, okay, and we don't need a court order. However, I've had some where they have the clients sign these, or ask the clients to sign these totally absurd indemnifications. And I have said, no, we're not signing that. And would then say, just go to another institution, move your money, because I don't really want to bother getting an order.
And Georgia, as usual, I never thought of that. Move your money is a good solution.
Okay.
Yep. And again, the other part of it too is that the orders. I mean, obviously, I get paid to draft the orders, so I'm biased, but it's not that burdensome.
Good.
If it's $1,650, or if it or $1,100, if it's less aggravation to just get the order, just get the order, right? That's what it comes down to. And so I think there's also the IRA questions that were posted in the chat thing there that I hadn't looked at before. So yeah, do I advise a quadro for the IRA? We try to avoid them. We try to do the letters of instruction or get the proprietary forms, that they have. And if that's good enough, usually with a copy of the judgment of divorce, usually we're good to go. I said about 25% of the time they tell us they want an order, so we draft an order.
I have problems with the dates because I think sometimes you have earned your contribution prior to the date of commencement, or you've earned it prior to the, when is it deemed made? When is a contribution contributed? Is it the date of actual contribution, or is it the date that they got the right to that contribution?
You know what? That's a problem I have not seen brought up before. If the 401k contributions come, with a lag, Yeah, I've never seen the topic broached. We've seen it with bonuses, right, all the time, in divorces. I have not seen it come up with the four.
Welcome to Westchester.
Yeah. Yeah, I mean, in theory, I can absolutely see your point, right? If the 401k contributions are made in December, and you're divorced in September, right? Yeah, I certainly see the argument for it. Just
And of course you do that.
I don't do it. Yeah, I certainly don't do it. I have to look and see what the separation agreement says, right? That's a good question. It says the marital portion of the account. Yeah, I've always cut it off on data commencement. I have never looked past the data commencement to see if there's a contribution that arguably was marital. So now I got a whole nother reason to stay awake at night.
Call me. I'll give you more.
Yeah. Yeah.
Okay.
Mhm.
But in drafting the separation agreement, I guess one would look for that date. Say, allocated as of that date.
Yeah. Listen, I
Also have an issue with when does something start? Because is it when you become a member of the plan or when you start working for the company?
I think just from a consistency perspective, I think it would be when you're eligible to participate in the plan, right?
Eligible or actual?
I think with a 401k, I don't know that there'd be a difference.
But in pension plans, there would be.
I don't know. Eligible? I don't know. Right, because your employers are obligated. With the 401ks,
401k, you're correct. It's not a problem.
right. In the pension plan, I don't know that I've never heard of anybody opting out of the pension plan.
No, but sometimes you have to be working there 6 months before you're eligible to join a plan.
Right.
Or 2 years. And do you start the measurement with the date of hire or the date you become a member of the plan?
The wording for most of the pension plan orders that are doing a Majauskis type formula is, the number of months of service credit, right? So if you're not getting service credit for it, then it doesn't count in the numerator or the denominator of the Majauskis fraction. So it's not just, days, it's got to be tied to service credits.
And when they get incentive service credits for retiring early, what do we do with that?
Typically prorated, right, into the numerator and denominator in a New York State pension. Union plan, who knows? Would have to investigate to see how that would happen. But a lot of times, most of your separation agreements that I see coming from Dutchess or Westchester, will have language in them that says, we're going to divide the pension benefits, including any early retirement subsidies, right? So it takes it out of my hands. And
Good.
yeah,
And we should note it, but in either including or excluding. But
yeah,
we should state.
yeah.
I'm saying excluding.
On the pension side, yeah, if you've got the participant, you definitely want to exclude them, right?
Oh, all right, well,
No, if
listen,
you have the alternate payee, you want to exclude them.
I think we're looking at a part 3, Georgia. I don't know.
Yes,
Yeah.
part 3 will do pensions, and we're gonna have Caroline and Bob, and I'll
Okay.
I'll tell jokes.
Okay, we got a plan. Well, we need a topic maybe for April. So I want to thank Bob for your expertise and your time this morning, and Georgia and also Alan for facilitating this. And if people want to get in touch with you, Bob, is there a good place? How do they reach you? With any-
we've got a website, I can put it, I don't know if this chat boxes stay, but
Yeah. We can follow up. I think your contact information was also, I think, on the announcement as well, but it's in the chat. So thank you. And
Yeah,
thank you everyone for attending. This was so informative and so helpful for our
And we would like,
practices.
Bob, if you could post or send to Melissa a copy of your retainer agreement so that we would understand what we're doing when we hire you.
That's a great idea. George, Bob, would you be able to do that?
I'm doing PR for him now,
yeah,
so.
that's it. I know it's they're just full service here. Yeah, I did post my phone number, and I'll tell you, I'm a compulsive phone answerer. I know it's bad for my productivity, but you know, we
You like
don't
the
do
phone?
we don't do a lot of trials, so I do sit in my office a lot. And
Okay.
you know,
So we'll call you.
after I've drafted the fourth order, I'm happy to answer the phone. So you know,
All right.
yeah, feel free to call.
Thank you so
Thanks,
much.
Definitely.
everyone.
Thank you so much. Thank you, everyone.
Alan, thank
Great
you.
presentation.
All right.
Thank you, Georgia.
Nice meeting everyone.
Bye-bye.
Nice meeting you. Mm.
Here's the- Hello? Okay, give me one second. Thanks.